I'm Ben Meiselas from the MeidasTouch network. Donald Trump and his lawyers, including his new lawyers, may now face more sanctions after federal judge Donald Middlebrooks in the Southern District of Florida just rejected a motion for indicative ruling filed by Donald Trump at the end of July, where Trump tried to revive the completely frivolous case that was dismissed, whereby Donald Trump sued Hillary Clinton and about 32 other individuals in a case where federal judge Middlebrooks sanctioned Donald Trump and his lawyer Alina Habba first approximately $66,000 and then close to an additional $1 million based on the frivolous nature of the case. But that wasn't enough for Donald Trump and his lawyers. He actually got new lawyers as well, the Banal law firm. They represented him in some other things. Some rookie first-year or second-year associate named Jared Roberts was one of the lawyers who helped file this indicative ruling. I criticized it in a prior video. I said, you're going to lose. The judge is going to mock you. This is a completely meritless filing. You don't know what you're doing, second-year associate. And then he responded on Twitter or X or whatever saying, thanks for the free publicity, hacks. And I said back then, well, let's wait until Judge Middlebrooks rules on your completely frivolous motion. And Judge Middlebrooks has ruled one of the more scathing motions I've ever read because it is entirely and completely frivolous. Are you ready to read a takedown of epic proportions by a pro-democracy federal judge of Jared Roberts or whatever his name is, and Donald Trump and Trump's lawyers for bringing this completely baseless indicative ruling? What the indicative motion is saying is revive the case that you found already frivolous and that you've sanctioned people over $1 million or close to $1 million for. And the reason why Donald Trump's lawyers were asking for this indicative ruling now is they said the Durham report by John Durham has made a seismic change in this lawsuit and it's proved all of the allegations. And as I said, no, it didn't. If you actually read the Durham report, reading and actually looking what it says, the only thing the Durham report said in conclusion is that it thought that the FBI should have conducted a preliminary inquiry before starting a full inquiry. Makes no recommendations, no changes. The Durham report led to no convictions during any of the jury trials that were brought. In fact, there were two individuals who were found to be completely innocent that John Durham tried to prosecute. Think about it like this. Okay, the Department of Justice has prosecuted how many of these insurrectionists? Over 1,000. In every single jury trial, every single one, the Department of Justice has won a conviction in all the jury trials. Okay, we're talking about hundreds and hundreds, over 1,000 people have been charged. Okay, the two cases that Durham brought, Durham lost. Why? Because there's no evidence. And MAGA Republicans live in their Fox OAN echo chamber devoid of evidence. Let's take a look at this scathing order. This Middlebrooks takedown is incredible. Judge Middlebrooks goes, on May 12, 2023, Special Counsel John Durham submitted his report on matters related to intelligence activities and investigations arising out of the 2016 presidential campaigns. Plaintiff and his lawyers tout the report as newly discovered evidence, and they now ask me to reconsider my previous rulings, but far from, quote, seismically altering the legal landscape of this case, the Durham report changes nothing. Nor could it really. Even if the Durham report uncovered the sort of vast conspiracy alleged by plaintiff, it plainly did not, by the way, but just assuming it did, it would still not change the many legal conclusions I made in the order dismissing Donald Trump's lawsuit. And whatever the Durham report can be said to have uncovered for purposes of this case, it does not change my findings that movements, Donald Trump and now his new lawyers, acted in bad faith in bringing this lawsuit, and that this case exemplifies Trump's history of abusing impeding the judicial process. Therefore, for the reasons set forth below, plaintiff and his lawyers' motion for indicative ruling based upon new evidence is denied. The court goes over some of the background, like on September 8, 2022, in a 65-page order, I dismissed Trump's amended complaint with prejudice to all non-federal defendants and without prejudice as to the United States. Given the frivolous nature of the case, I reserve jurisdiction to adjudicate issues pertaining to sanctions. On November 10, 2022, I granted one of the defendant, Dolan's, motion for Rule 11 sanctions. In the first sanctions order, I imposed $66,000 of sanctions to plaintiff's lawyer Alina Habba, Michael Medeo, and the Habba, Medeo, Peter Trinken, Jamie Allen Sassone, the Tinkin law firm. On January 19, 2023, I granted 18 other defendants joint motion for sanctions under this court's inherent powers. In the second sanctions order, I imposed nearly 938,000 sanctions on plaintiff Donald Trump and plaintiff's lead attorney Alina Habba and Habba, Medeo and Associates. Between late 2022 and February 2023, plaintiff and his sanctioned lawyers appealed all three orders to the 11th Circuit. Now they talk about now they're bringing this indicative ruling here. And then it goes on to discuss the Durham report briefly and says the movements seek an indicative ruling, movements being Trump, seek an indicative ruling from this court given the Durham report. It would grant the Rule 60B motion if the 11th Circuit remands jurisdiction of the case. So then it goes on to talk about the standard for indicative rulings. And then it goes on to say, the Durham report is not newly discovered evidence because a party cannot discover something that did not exist at the time of trial or hear the final orders. Movements also do not point to a single fact in the report that even with due diligence they failed to discover. To the extent that plaintiffs can pluck out arguably favorably sounding facts from the report that may have some conceivable tie into his conclusory allegations, that doesn't affect the many legal conclusions that I set forth in my motion to dismiss order. I highlight some here and then he gives the highlight, but just think about the art, the poetry of that language by Judge Middlebrooks here. It goes, so to the extent Donald Trump can pluck out arguably favorable sounding facts from the report that may have some conceivable tie into his conclusory allegations that doesn't impact the legal holdings that I've made. That's what Trump's been reduced to, is if you can even mutter a sound that can conceivably demonstrate something that even vastly interacts with your conspiracy, it still wouldn't freaking matter, is what the judge is saying. Now, here are some of the judge's legal conclusions. Like, plaintiff's amended complaint is a quintessential shotgun pleading, and courts in the 11th Circuit have little tolerance for these types of shotgun pleadings. Because the United States is the proper party to this action, plaintiff was required to exhaust administrative remedies before bringing this claim. So you failed to do the threshold thing. You failed to, once again, Alina Habba, check the prerequisite box. Plaintiff has not alleged that defendants aimed any conduct at Florida or could have reasonably anticipated plaintiff would be harmed in Florida. Plaintiff's allegations compel only one logical conclusion. The plaintiff was aware of the factual basis underlying his RICO claims since at least October 2017, if not earlier, thus placing his RICO claims outside of the 4-year statute of limitations. Plaintiff misunderstands the law. Plaintiff's concession that he was damaged beginning in September 2017 means the clock began ticking. Despite that, plaintiffs did not yet appreciate the true extent of his injuries. Obstruction of justice does not supply plaintiff with a valid predicate act because plaintiff does not identify any official proceeding that defendants allegedly obstructed. Even accepting plaintiff's allegations as true, perjury and falsifying documents are not RICO predicate acts, nor does misreporting payments to Fusion GPS campaign finance reports qualify as wire fraud. In dismissing count 10, I explained that there is no freestanding independent cause of action in Florida for agency. He just goes on and says, I rejected all of the legal claims that you've made, setting aside, even if you come back and say there's a conceivable conspiracy here, which is not the basis to even supply these claims. I've rejected them already on the basis of the law. And the court says this, I struggle to even imagine anything that the Durham report could say to warrant a change in any of those conclusions, the sum of which, by the way, any of which would foreclose it, but the sum of which foreclosed plaintiffs' claims and led to sanctions. And after reading all 306 single-spaced pages of the Durham report, I am not convinced that anything it does say merits the extraordinary relief granted in a Rule 60B motion, a total and utter takedown. So now the question is, will the defendants who had to respond to this yet again seek sanctions motions from the court? I certainly hope they do, but what a takedown right here. What a takedown. Jared Roberts, you said, thanks for the free publicity. Hacks Trump 2024 with an American flag. Shows how mature you are. Well, there you go. There you go. Welcome to the practice of law. I'm Ben Meiselas from the MeidasTouch Network. We're on our way to 2 million subscribers thanks to your support. Check us out at patreon.com/MeidasTouch, patreon.com/MeidasTouch. And check us out at MeidasTouch.com as well. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram at MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.